Right. I think we'll kick off. Good morning, everybody. Welcome to the third of our employment law updates for the year. Those of you who don't know me, I'm Damant. Just a couple of housekeeping rules. Just because we're using the webinar format, you'll note that all of you are muted. You will be able to ask questions using the Q&A function at the bottom of your screens. I will try and keep an eye on the questions and try and monitor it and deal with a couple of the questions as they arise. I can't guarantee I'll deal with every one of the questions. The session is being recorded, so for those of you who want a recording, it will be available on our website after the session. For those of you not familiar with employment law update format, we've been presenting this for the last 35 years. We last year brought it in-house into Bowman's, and we've been presenting it in this webinar format for the last year. The idea behind the ELU is to basically update you with the latest developments in the law so that you're familiar with what's going on. And what we found over the last 35 years is that the law is constantly developing. Every time we think we've got something settled, we get a different case that tells us we've been wrong for the last 35 years. So it's developing all the time. The other idea is to basically give you some practical cases that will help you deal with workplace issues. We've got a panel of presenters representing both experienced presenters in the form of Talita and Lusanda, and a whole lot of up-and-coming rising stars that I'll introduce you to as we progress. Before we move into the case law presentation, I just want to touch on a topic that is the sort of hot topic of the moment, and that is the issue of the introduction of mandatory vaccines in the workplace. You will see a lot of publicity in the newspapers about people expressing opinions. We've got companies announcing the introduction of mandatory vaccination policies. It started with Discovery, then Sanlam, then Old Mutual, and a variety of other organizations. I'm aware that we currently have advised approximately 18 large employers on the introduction of vaccines, the majority of whom are introducing mandatory vaccines. But Talita, over to you just to update us on the latest thinking around mandatory vaccines, and then we'll move into the program.
Thank you, Graham, and good morning, everyone. It is great to be with you, and I honestly cannot believe that we are on the 26th of November of this year. But yeah, here we are, ready for a holiday, I'm sure. Broadly speaking, what governs the introduction of vaccines in the workplace is the direction that is published under the Occupational Health and Safety Act. And that direction makes provision for an employer to do a risk assessment, to check which employees in its workforce are at higher risk of transmission of the virus through their work, and who may accordingly have to be required to get the vaccine in order to ensure their and fellow employees' safety. It also regards vulnerable employees as being particularly prone to having, being at risk of transmission of the virus, and they can accordingly also be in this category to get or to be required to get the vaccine. Now, this assessment must then be contained in your workplace plan, and you would also need a vaccine policy in order to communicate your plans to the workforce. It needs to be consulted on by employees and definitely the Health and Safety Committee. And then the employer needs to implement it. Importantly, there must be provision for objections on constitutional grounds. These grounds include religion and also medical grounds. So if there is a medical contraindication, such as the risk of an allergic reaction to one of the components of the vaccine, then obviously that needs to be taken into account. The employer needs to seriously consider these objections, and where appropriate, then accommodate those objections reasonably. The employer is not, it's not an absolute obligation, and there may very well be circumstances where reasonable accommodation isn't possible, but that needs to happen in, again, a consultative way and with proper and serious consideration of all the facts presented. As Graham mentioned, we have advised many clients on this issue over the last 2 months or so, and we have seen a range of approaches. There are clients who want to make the vaccine mandatory for every employee, irrespective of whether that employee works from home or not. And then you have a more balanced approach, perhaps in relation to clients who say, well, our employees are specifically at risk because we have an open plan office, they stand around plans. In an engineering company, for example, they are in close contact. It isn't reasonably possible to ensure adequate space all the time. And therefore, for those categories of employees, we are making it mandatory to get the vaccine. For office workers, we do not need that, someone that's in their own office. And then you have employers on the right and the other side of the spectrum who are saying it's, it's not necessary. The safety arrangements that we have in place are sufficient in order to protect people. Of course, we are encouraging people to get the vaccine, but we are not going to make it a requirement to come into the office. Ultimately, what we see is it is a matter of risk assessment. So you would assess on the one hand the safety risks and bearing in mind the employer's obligation to ensure a safe working environment for all employees, but also everyone who comes into those premises and who have contact with your employees. That is a very important factor to take into account. Then also there's the risk of claims from employees, especially if reasonable accommodation isn't practicable. There's also reputational risk that you need to take into account, and all of those things go into the mix in order to then develop your plan. I've just seen this morning that there is a new variant, the Botswana variant, and it will probably get a name during the course of the day by the WHO. And apparently this is a highly transmissible and vaccine resistant variant. So we will need to properly take into account the medical evidence again in relation to this variant in the formulation of these policies. But yeah, it is, as Graham is saying, it is a moving target, and we have learned to be very quick to adapt to changing circumstances. And again, this is one area where employers will need to have their finger on the pulse and will need to adapt as the facts become more clear.
Thanks, Steve, for that. That was very useful. Then we'll move now straight into the case presentations. We're going to start off with a series of strike cases. We seem to have a lot of strike cases on the program today. So we're going to move straight into the first constitutional court case of AMCU versus Anglo Gold. Lusanda, head of the Employment and Benefits Practice, is going to take us through this case. Lou, over to you.
Thanks, Graham, and good morning to everyone. So what happened in this case is that there was a primary strike in place in relation to Sibanye mining, which is in the gold and platinum mining industry. AMCU, which is the trade union that was involved in the primary strike with Sibanye, after a period of time of being in the primary strike, decided to go on a secondary strike in relation to a variety of other mining companies, being Anglo Gold Ashanti, Lonmin Mining, Rustenburg Platinum, Harmony Gold, Village Main Reef, Impala Platinum, Bushveld, Vatne, Glencore Operations. So what AMCU then did is that it decided in going on the secondary strike that employees of these other mining companies would also be going on strike. And this case primarily then rested on three questions. The first question in relation to Section 66(2)(c) of the Labour Relations Act, and looking at the principle of proportionality when looking at the lawfulness of a secondary strike. Therefore, the proportionality of the impact of the secondary strike. There were two other issues that came up. The second issue being whether, in looking at it, it should be looked at in relation to each of the mining companies involved in the secondary strike, or the cumulative effect combining all of the mining companies in the secondary strike. And the third question, which was raised by AMCU, was in relation to previous violence. So the mining companies, in relation to the secondary strike, said that the strike was likely to be violent because of previous violence in relation to AMCU strikes, but also because of previous violence in relation to the primary strike. And this was also an issue that the Labour Court then had to look at. Just some brief other facts in relation to the circumstances. The secondary strike was planned to be put into effect for a period of 1 week. But even though it was only due to be in place for 7 days, and it was only due to impact 2% of the working year of the companies involved in the secondary strike, the daily losses of each respondent would have been estimated to exceed 11 million rand, and as much as 214 million rand may have been lost in one instance in relation to one of the companies. And cumulatively, over the period of 7 days, it was anticipated that the losses to the respondents would have exceeded 2 billion rand. There were also practicalities around safety, because the secondary strikes would have necessitated total shutdowns in relation to those mining companies, and what that would have meant for those companies. And as I mentioned, there was also a concern of violence, particularly because in the primary strike, already 7 non-striking employees of Sibanye had died. So starting at the principle of proportionality, the Labour Court had held that Section 66(2)(c) required consideration of the direct or indirect effect of the secondary strikes on the primary employer, while also entailing an inquiry of the impact on the secondary employer, having regard to the nature and extent of the secondary strikes. It was ultimately a proportionality assessment to determine whether the harm caused by the secondary strikes to the secondary employer was proportional to their impact on the business of the primary employer. The Labour Court had held that the secondary strikes in this matter would result in severe disruptions to the businesses of the secondary employers. And because of that, it held that the secondary strikes were unlawful. AMCU then applied for leave to appeal to the Labour Appeal Court. And the Labour Appeal Court, although leave to appeal in itself was refused, the petition to leave to appeal was refused, the Labour Appeal Court did, though, endorse their interpretation in the Salga cases that imports the proportionality test and weighs in on the effect of the secondary strike on the secondary employer and the effect of the nature and extent of the secondary strike on the business of the primary employer. And therefore, it was held that if the secondary strikes impact disproportionately harshly on the secondary employers as a party uninvolved in the primary strike, the secondary employers would be entitled to interdict the secondary strike. In relation to the other issues, in looking at whether the impact had to be individual or collective, The Constitutional Court said the Labour Court had already determined in this case that there would both be an individual and cumulative effect in relation to the secondary employers in the secondary strike. And it held that the wording in the Labour Relations Act can be read to see both individual and cumulative impact. And it held that both individual and cumulative impact should be taken into account. In relation to the third question, the question of violence, and AMCU having made representations that the fact that there had been violence in previous strikes and the fact that there had been violence in relation to the primary strike did not necessarily mean that there would be violence in relation to the secondary strike. The Constitutional Court said that those considerations were valid considerations. It held that the fact that there had been previous violence and that there had actually been violence and deaths in relation to the primary strike were valid considerations. And therefore, in relation to the three questions, the response from the court was that proportionality was valid. It held that in relation to impact, both individual and collective impact was valid. And in relation to violence, it held that previous violence was relevant to be taken into account in determining whether or not in relation to the secondary strike, there was likely to be violence.
Thanks, Lou. That very interesting concord, and I think quite sort of pleasing for employers to know that there is some limitation on secondary strikes and that unions can't just go out and strike to try and put pressure on the primary employer that's involved in the strike with the demands. Let's then move on to the second of the strike cases. It's a case that involves a union that goes by the interesting name of the Influential Information and Communications Union, and SAPO. And one of our up-and-coming rising stars, Nadine, who's a senior associate in our Joburg office, is just going to take us through that case. Thanks. Nadine, you're on mute. We cannot hear you. See, it's not just me that can't hear Nadine. Okay, so Nadine, can you log off and come back in when you've got your voice back? And in the meanwhile, we'll jump over to the next of the cases, which is the Labour Appeal Court case of Sasol and Schlapper. Melissa Cogger from our virtual Cape Town office is going to present to you on the Sasol versus Schlapper matter.
Thanks, Graham. Can everyone hear me? Yeah, so this matter dealt with an unprotected strike that occurred 12 years ago. So it occurred in 2009 at the Sasol coal mine near Secunda. And it made its way to the Labour Court and then eventually to the Labour Appeal Court, with judgment recently being handed down in September of this year. So in that case, 950 employees had embarked on a 3-day strike across 10 underground shafts. And part of the strike occurred above ground and other parts of the strike occurred in the actual mines. And the strikes created severe health and safety risks. It prevented safety teams from undertaking their 3-hourly patrols to monitor methane buildup underground, which would then prevent underground explosions, potential flooding, and rock falls. And not only were there serious breaches of mine and health safety procedures, there were also employees who were being held underground against their will. They were threatened and physically attacked, and they were harmed by some of the striking individuals. And the strike related to the employer's alleged failure to make a bonanza payment. So it was a bonus of 9,000 Rand that each of the employees believed they were entitled to. And the employer, of course, said there was no agreement for such payment, nor was there an entitlement. And what had been agreed to was a 6.5% increase. So the employees declared a dispute, and when the employer approached the employees' union, which is the United People's Union of South Africa, the union refused to intervene. And then there was a local shop stewards council on the ground who sought permission from the employer to march to the Secunda offices to hand over their demands, and permission for this was refused. So notwithstanding permission being refused, the local shop steward council embarked on the strike, and those members were then suspended. Now, the employees who were underground were refusing to engage with the employer at all. They wanted to only engage through their local shop stewards council members. And interestingly, in this case, some of the employees were actually striking off duty. So they had showed up for their shifts, their 10-hour shifts, and once their shift ended, they then participated in the strike. And the employer suffered significant economic harm. Mine production was halted for several days, and it could only commence several days after the strike ended. And the only way in which the employer could stop the strike was approaching the Labour Court for an urgent interdict. Once the Labour Court granted the interdict, the employer then went to dismissing 636 employees. So it used over 20 different chairpersons and conducted a number of disciplinary inquiries. The Labour Court found that the dismissals of the employees was substantively unfair and held that the employer did not make a good faith attempt to engage with the local shop stewards to end the strike. And historically, the employer was inconsistent in previous strike action where there was a 4-day above ground strike, and those employees were given final written warnings. They were not dismissed. So in the Labour Court, the court granted 12 months compensation, or for those employees that wanted to be reinstated, they were permitted to be reinstated. It was then taken on appeal to the Labour Appeal Court. And one of the claims made by the trade union was that those employees that were striking off duty were not actually on strike. So that was one of the matters that the Labour Appeal Court considered, as to whether employees may still be considered on strike when they are striking off duty. And the Labour Appeal Court looked at the definition of strike action, and it found that those employees would still be considered to fall within the meaning of strike action because those employees had retarded or obstructed work through their physical and intentional conduct. So even though they were off duty, they were still participating in unlawful, unprotected strike action. The Labour Appeal Court disagreed with the Labour Court. There were good faith attempts to consult with the shop stewards, and they also found that the earlier strike in 2006 was distinguishable. The underground strike in this instance was far more dangerous than the 2006 strike. And there were serious consequences of the 2009 strike, which halted production, compromised mine safety, and exposed workers to serious personal risk. And in addition, no evidence was actually laid in the Labour Court, which dealt with a historical inconsistency. So in that case, the Labour Appeal Court found that the dismissals were procedurally and substantively fair. Thanks, Graham.
I haven't found my voice. Let's see if Nadine has found her voice and takes us through the influential thing. Nadine, are you able to speak?
Can you hear me, Graham?
We can, thank goodness.
Great. Thank you very much. Good morning, everyone. The case we'll be discussing today is a fairly complex case and was quite a lengthy judgment concerning a number of various employees. But ultimately it concerned a dismissal of around 227 employees, the majority of whom were members of the union as mentioned by Graham, the Influential Information and Communication Union, that is referred to as ICUSO, by your South African Post Office as a result of participating in an unlawful strike. Now, the issue that came before the Labour Court was whether the dismissals were substantively and procedurally fair. Now, just by way of background, briefly, SAPU is known to employ a number of casual employees as well as permanent employees. The casual employees are ordinarily employed on the basis of fixed-term contracts and perform similar functions to your permanent employees, however, received a lot less remuneration and benefits. Now, this was raised as a problem by a number of employees, And as a result, a sort of working committee agreement was reached that SAPU would take steps to convert a number of these casual employees into permanent employees. This agreement, however, was never implemented by SAPU. Shortly thereafter, the union approached SAPU in an attempt to get organizational rights. However, the union did not meet the representation threshold of 35% in order to get membership, either within your permanent employees or casual employees. And after referring a dispute to the CCMA, a sort of settlement was reached that SAPU would grant them sort of limited shop facility rights, but would not be allowed to or be recognized as taking part in wage negotiations. Shortly after that, SAPU actually entered into collective bargaining negotiations and introduced a new recognized agreement for your majority trade unions. Now, during the collective bargaining process, which took place at their head office, a number of workers gathered and marched to the head office. They started barricading the gates. And when SAPU went to understand what these workers were disputing, they said that they were unhappy about being casual workers. They wanted to be converted into permanent workers, and basically that the union should take part in these negotiation proceedings. Now, there was some dispute about how this took place, but it did come to light that one of your general managers of the union had actually created this WhatsApp group and had sent a message to all your union members to say, you know, guys, now's the time, something along the lines of all roads lead to the SAPU head office. Now, SAPU then requested a meeting with the union relating to this unlawful strike to take place in Germiston the next day. But instead of the union coming to meet with them, they were just faced with striking employees that damaged a significant amount of property and committed various acts of violence. In response to this, they reached out to the president of the union, who at the time was unfortunately in hospital. But according to the president, there was no strike. The union wasn't engaged in a strike. They were unaware of a strike, and they denied any sort of involvement in a strike. This was despite the fact that the members had identified themselves as ACUSU members and were wearing relevant trade union T-shirts. Now, following that, SAPU then issued an ultimatum to these employees. They said, you need to return to work. We reserve our rights to institute disciplinary action, failing which you will be dismissed. Only if your employees return to work. After that, the post office headed to the Labour Court. They got an interdict to interdict the strike, and they issued a second ultimatum, saying this is your second and final ultimatum. You're required to return to work, bearing in mind that participation in unprotected strike can result in your dismissal. A number of the employees still did not return to work. As a result, once a number of employees had returned to work, SAPU issued letters to all the employees, requesting them to make representations as to why they should not be disciplined or how they should be disciplined relating to their participation in an unlawful strike. The majority of these employees did not submit any representations. After that, SAPU decided to create their own sort of formula as to what sanctions should be applied in the matter. And basically how it worked was that, firstly, if the employees returned to work before the ultimatums, they would be charged in the ordinary course, which could be a verbal warning. If the employees returned to work after the ultimatums, but made representations which were justified, they would be issued with a final written warning. And the employees who failed to return to work and didn't make representations would be dismissed, or if they returned to work but didn't make representations, would be dismissed. This is the formula that they used in respect of the employees. So as a result of applying this, 227 employees were dismissed and about 55 employees received final written warnings. The union then took the matter to the court, stating that it was procedurally unfair, and substantively unfair on the basis, firstly, that there was inconsistent application in the sanction to employees as a substantive fairness issue, and on the procedural side, that they had not followed their own disciplinary code or provided the members with an opportunity to make, or an adequate opportunity to make representations. Now, when the court looked at the legal principles, they had regard, of course, to Schedule 8 of your Labour Relations Act, and the principles set out therein about how employees should regulate substantive fairness when you're dealing with individuals participating in unlawful strike action. And certain of the questions there to be asked was, what is the seriousness of the contravention of your LRA? Did the union make any attempts to comply with the Act? And was the strike as a result of unjustified conduct on the part of the employer? Now, the court noted importantly that even if a strike is declared unlawful or is illegal, this does not immediately render dismissal fair. The employer still has an onus to prove that the dismissal was fair in the specific circumstances, having regard to the guidelines set out in Schedule 8. So the court briefly went through these guidelines. They firstly found that the strike was a serious contravention of the LRA. It lasted for approximately 6 days. There was significant damage to property and incidents of assault. Secondly, the union's attempt to comply with the LRA was actually non-existent. I mean, in essence, they denied that the strike was even taking place, even up to the point that the employees were dismissed. So they found that the union made no attempts in order to comply with the Act. And lastly, that the strike could not have been a result of the unjustified conduct of the post office, because their strike was as a result of the union not being able to participate in collective bargaining negotiations, which was a consequence of legitimate recognition standards in a multi-union workplace. This was nothing on behalf of the employer. Now, when looking to the issue of consistency in the sanctions, the court noted that your principle of consistency, also referred to as your parity principle, is a principle of your basic tenets of fairness, right? It's that cases that are the same should be treated alike. So where employees have committed similar misconduct, they should be treated the same and not differently. However, saying this, they said employers must approach the issue of consistency with caution, because you may have instances where an employee in fact deserves to be dismissed, but because another employee who committed the same offence wasn't dismissed, can now not be dismissed. Specifically in your sort of large number of employees and this matter, you can only, the court said, hope for reasonable consistency. You can't expect absolute consistency in these circumstances. So it will only be unfair if the consistency was as a result of a capricious act by the employer or sort of improper motives. It's going to happen that there will be some inconsistency, provided that it is not sort of in bad faith. Now, the court did find that there were a number of employees that returned to work, made representations, but were dismissed, or didn't return to work and didn't make representations and weren't dismissed. So there was some inconsistency, but it sort of narrowed it down to 1 in 10 individuals had the opportunity to maybe escape dismissal if they were actually allowed to be dismissed. And in these circumstances, this was not significant enough to say that inconsistency should result in substantive unfairness. So they were not persuaded. They sort of felt, it was reasonably consistent, barring a few cases, and this was only one factor to be considered. It wasn't determinative of substantive fairness. Briefly, just moving to procedural fairness, the court briefly dealt with that even though the disciplinary code said that they must hold a hearing for employees, the post office said it was not practical in the circumstances to hold individual hearings or even a mass inquiry, and this evidence was not disputed. And further, at no stage did the union or employees request a hearing. In addition to the opportunity to make written representations and the fact that they didn't get enough time to do so, the union at no stage requested an extension or took issue with this until it was before the court. So the court found in these circumstances it was substantially and procedurally fair. There were a few individual cases that they dealt with on a case-by-case basis because of personal circumstances, but ultimately the finding was that the dismissals were fair, there was consistent discipline, and there was no procedural irregularities.
Thanks, Nadine. There's a question that's asked as to whether you could dismiss the shop stewards committee only if they had breached the collective agreement and incited people to embark on a strike. Could you select them for special treatment and dismiss them only?
So, Graham, that's a good question. I mean, in this case, there were certain shop stewards, and actually all of them were dismissed as a result of taking part in the strike and basically inciting it. In terms of consistent discipline, you would have to look at the issue of the offence. Arguably, they have a higher threshold and a duty now in terms of this agreement, which would provide you with a reason to dismiss them, or an actual breach of a workplace rule dealing with the collective agreement. But you would have to, in terms of the consistency, I don't think you could only isolate your shop stewards. If your shop stewards are participating in strike together with other employees, damaging property, etc., you would have to apply a consistent approach, and it could not only be isolating those shop stewards.
Thank you very much. Right, let's move on to the last of the strike cases and the first of the strike misconduct cases. So we're going to turn to the Max Steel Services Centre case. And then, Sibu, I'm going to ask you to go straight on to the first of the strike misconduct cases, which you're also dealing with. So these will be presented by Dube, again, another rising star in our Joburg office, a senior associate who's practicing in our team. Sibu, over to you.
Thanks, Graham, and a good morning to everyone. So the first case that I'm dealing with is Max Steel versus NUMSA. And this is a case where Max Steel had approached the court for an urgent interim interdict to stop NUMSA and its members from embarking on a strike. The brief background is that the Max Steel belongs to the MEIBC, and NUMSA represents a majority of Max Steel's employees. So NUMSA and Max Steel are therefore bound by the constitution of the MEIBC. Now, NUMSA wanted to initiate plant-level negotiations with Max Steel, and they sent a letter to Max Steel indicating that that's what they wanted to do in respect of various employment conditions of their members. In response to this request, Max Steel said that that sort of bargaining must actually be taken to industry level and not plant level. Now, in response, NUMSA then referred a dispute to the MEIBC, a refusal to bargain dispute to the MEIBC. And at the MEIBC, Max Steel raised a jurisdictional point in limine, in terms of which they objected to the jurisdiction of the MEIBC, stating that, the decision on whether or not an issue should be determined at industry level or plant level is actually one that must be determined by the President of Council in consultation with the Secretary of Council. So that was the jurisdictional point that was raised by Max Steel, and the commissioner at the bargaining council upheld the point that Max Steel had raised and issued a ruling stating that the MEIBC does not have jurisdiction to conciliate the dispute. Now, NUMSA took that jurisdictional ruling as an advisory award, because when we're dealing with a refusal to bargain, a dispute that involves a refusal to bargain, you need to obtain an advisory award. So NUMSA took the jurisdictional ruling and said that, the ruling is advisory in nature. One needs to actually consider the substance of the ruling and not the form. And because the ruling is advisory in nature, they have obtained an advisory award, and they then issued a notice that they would be embarking on strike. Now, in response to that, Max Steel then approached the labor court on an urgent basis, and basically the argument was an advisory award has not been obtained because there's a jurisdictional ruling which says the MEIBC cannot adjudicate the matter. NUMSA's argument was, as I've indicated, that the ruling is actually advisory in nature. Now, in considering the two arguments, the court held that one actually needs to look at the purpose of section 64(2) of the LRA, which states that you need to first obtain an advisory award. And in doing so, the labor court referred to the explanatory memorandum to the LRA, which basically stated that it is accordingly proposed that disputes concerning the refusal to recognize a trade union or the withdrawal of recognition or the refusal to establish a bargaining council or the resignation from a bargaining council should be thoroughly conciliated and referred to advisory arbitration before resorting to industrial action. Now, in amplification of that argument, the judge also considered a decision in Cogger projects versus the CCMA, where Judge Legrange had also stated that, in this case, when the second respondent was required to determine a jurisdictional ruling, he should have also issued an advisory award. And that because there was no advisory award in that case, the strike action in that matter would therefore be unprotected or unlawful. So in essence, the court then went on to find that, the strike that NUMSA wanted to embark on would be unprotected in the absence of an advisory award. The second leg of the judgment was related to the secondary relief which Max Steel had provided for in their notice of motion. And that was that the strike should be interdicted pending an advisory award being obtained. Now, NUMSA argued in the alternative that they would concede to the secondary relief if the court exercised its powers in terms of Section 158 of the LRA and actually ordered the MEIBC to issue an advisory award. Now, Max Steel argued that the commissioner could not issue an advisory award because he has already ruled that he doesn't have jurisdiction to hear the matter. The judge disagreed with this argument that Max Steel presented and basically stated that the commissioner was not functus officio in regard to this matter, as he had not discharged all his duties as a commissioner. The judge stated that the commissioner was vested with the matter and that the commissioner had tried to escape his duties by relying on a technical point. So therefore, the matter was still with the commissioner and the commissioner could still exercise a certain function. So the court ultimately ruled that the strike would be unprotected, however, compelled the MEIBC and the commissioner to issue an advisory award within 3 days, and that the strike would then be protected once an advisory award had been issued by the MEIBC. So that is the first case. Can I jump on to the second case, Graham?
Please, thank you. Yeah, these questions of advisory awards over the duty to bargain and the bargaining levels are always complicated. And the advisory award ultimately doesn't mean anything because it's merely advisory. So you can ignore it and then go on strike, but it's meant to guide the parties as to what level of bargaining you're meant to engage in for what it's worth. But anyway, let's move over to the strike misconduct case. Thanks.
Sure, thanks, Graham. So the next case involves SPAR Eastern Cape Distribution Center and 37 employees. And it is an arbitration award in terms of Section 188A of the Labor Relations Act. The brief background to the matter is that, the union involved in this matter is the Transport, Retail and General Workers Union. So the union in this matter approached SPAR with a wage demand, and the employer refused to accede to the wage demand. As a result, a dispute was referred to the CCMA, the matter was conciliated, a certificate of outcome was issued, and picketing rules were also issued to the parties. After that, a strike notice was received by the employer, and the union and its employees embarked on a strike. Now, during the strike, the picketing rules were violated, and the employer then issued a notice to the union and its members that, they are violating the picketing rules, and if they continue to do so, the employer would have no recourse but to approach the labor court on an urgent basis to interdict them from violating the picketing rules. They continued to violate the picketing rules, and an urgent interdict was obtained by the employer. The urgent interdict was served on the employees, and that did not stop them from violating the picketing rules. So there was then conduct of, employees blockading the entrance to the employer's premises. They blockaded the entrances to premises of other employers within that vicinity. They burnt tires, and there was a lot of violence that was instigated by the union and its members. Police were called to come onto the scene, and they tried to disperse the crowd. It became rowdy. The crowd started throwing stones at the police. The police had to use tear gas and stun grenades to disperse the crowd. And that's essentially the background to the misconduct by the employees. Now, as a result of that, the employer decided to discipline these employees. They entered into an agreement with the union that the matter would be dealt with in terms of Section 188A of the Labor Relations Act. Now, before the arbitrator, there was evidence of video footage, there was photos, and there was oral evidence. And the union argued, or rather the union and its employees, they argued that they had not committed any misconduct, that there was no proof of misconduct, and to the extent that they had violated the picketing rules, the employer could not subject them to a disciplinary inquiry for violating picketing rules. So the first issue that the arbitrator then dealt with was whether or not he could admit the video evidence that was presented to him during the inquiry. And in a nutshell, he held that the video evidence was relevant, it was admissible, and there was a witness that spoke to the video evidence, and that this witness was subsequently cross-examined. Therefore, he regarded it as being reliable. The second question that he was then faced with was whether or not the employer could actually discipline the employees for violating the picketing rules. And the charges against these employees, they related to violating the picketing rules and also violating a court order. So the arbitrator found that there was no reason why the employer cannot discipline employees for that conduct, because it's within an employer's prerogative to discipline its employees. The third question then related to the identity of the perpetrators of the misconduct. And the commissioner then ruled that, considering the oral evidence that was before him, considering the CCTV footage that he had considered, the affidavits that had been submitted, he was satisfied that the employer had proven the case on a balance of probabilities, that it was in fact the members of the union who had actually participated in the unlawful and violent conduct. He, however, found that in respect of 3 employees, the evidence was that they had only arrived at the scene after the police had dispersed the crowd. So he found that there wasn't sufficient evidence in respect of those 3 employees, and they were found not guilty. With regard to the others, the commissioner found them guilty and ruled that dismissal was an appropriate sanction because of the nature of the misconduct, the fact that they had burnt tires, they had acted, in a manner that was against the labor court order, and he felt that the conduct was of such a nature that it rendered the employment relationship intolerable going forward. And the 33 employees were then subsequently dismissed.
Thanks, Abu. I think it's just indicative of a trend that we're seeing where the courts and the arbitrators are stamping down on strike misconduct because of its prevalence in this country. And so they're taking quite a hard line on it, but also the importance, I think, of an employer getting evidence, particularly using video evidence and whatever photographic evidence to try and identify people involved in strike violence while the strike is underway. Nadine, I think you're going to deal with the next of the strike violence cases, which is the Whirlpool case in Palmer.
Thanks, Graham. So this case concerned a review application in terms of Section 145 of the LRA. And briefly, just in terms of the facts, the company, which is in the industry of sort of manufacturing refrigerations, suffered a sort of quite a small and unique strike within its operations. What happened was that a group of employees approached the HR office in relation to a return of money that they alleged had been deducted from their salaries, although they were deducted in response to acknowledgements of debt. Now, as a result of HR not paying them the money, they proceeded to participate in a strike and walk around the premises, toying, dancing, sort of inciting other employees. Now, the employee concerned in this regard was seen as the company as a front runner in the strike. She was blowing a whistle, she was acting in an aggressive manner, she was toying, and when she came to the various departments, the employees that were still working sort of ceased working, and the majority of them hid behind machines on the fact that they were scared that they would be subject to some sort of harm as a result of the striking employees. Now, thereafter, these employees were subject to disciplinary action, and the specific employee concerned was charged with the intimidation and incitement of other employees during the strike. She denied this. She said that she simply was dancing, she was blowing a whistle, she didn't know that she wasn't allowed to blow a whistle, that it was a breach of a workplace rule because she often blows a whistle when she goes and sings at church. So to her, it was more of part of singing and dancing, and there was no intimidation. When she spoke to employees, she had stopped to employees and spoke to them about their children. She hadn't asked them to stop working, so she completely denied the charges. Notwithstanding this, the employee dismissed her. She then referred an unfair dismissal dispute to the bargaining council. And at the bargaining council, the company led one witness, one of the managers, that had cited the striking employees, and also video footage of the strike. Now, this witness testified similarly that she was the front runner, she was blowing a whistle, she was aggressive, she was toying, and she made these employees scared. He witnessed these employees ceased working and made them scared. Again, she denied this. She also called a fellow employee as a witness, which was one of the employees that the company said she had intimidated, and this fellow witness then denied the intimidation. Now, the commissioner interestingly found that having regard to the employee's body language and the blowing of the whistles during, working hours, this did not prove the charge that she was faced with. Yes, the employee was blowing a whistle, and yes, she was toying and singing and dancing and participating in leading an illegal strike. But this was totally different to what she was charged for, said the commissioner. The applicant was charged with inciting and intimidating employees. And the commissioner found that the company had not discharged the onus of demonstrating that she was guilty of the intimidation and incitement, and accordingly found that she was unfairly dismissed. Now, the company then reviewed the award. And the relevant issue here in terms of process is not necessarily in relation to the strike or the misconduct, but it was in how the actual commissioner dealt with the evidence. So the company on review alleged that the commissioner had committed a gross irregularity in relation to the fact that he came to an unreasonable conclusion, but in particular that the company contended that the commissioner's assessment of the competing versions of evidence, so the versions of the company's evidence and the employee's evidence, constituted an error of law. He didn't correctly apply your balance of probabilities test. So he failed to properly assess the evidence that was before. Now, the court, of course, held that your well-established test on review is that whether the decision made by a commissioner is one that is reasonable or a reasonable decision that can come to. Referring to case law on the matter, they obviously said in relation to your reviewable irregularity, it's got to be a gross irregularity. It's got to be a decision that is, arrived at by someone who cannot be reasonable in the circumstances. But specifically looking to case law on the issue of the resolution of competing versions of evidence, the court found that there was a test to be applied. The commissioner was required to firstly consider the versions, test the credibility of the various witnesses, test their reliability, and then also consider the probabilities of the version put forward the commissioner. Now, then when it came to evaluating these tests with regards to the fact, the court held that what the commissioner did in relation to handling the two competing versions of evidence was problematic. So the commissioner's view was that the company only called one witness. They should have called other witnesses. They had an opportunity to call other witnesses, but they chose not to. And this witness's evidence was based on a perception that employees were scared. Now, the court held that that was wrong. And the reason for this is that the evidence led by the company's witness was not challenged, wasn't disputed by the employee. Yes, the employee said that she wasn't a front runner. There were 3 employees at the front, and she didn't know she was allowed to blow the whistle. But the remaining evidence was not actually disputed by the employee. Referring to your constitutional court judgment in terms of your president of South Africa versus your South African Rugby and Football Union, there the Court really emphasized the importance of evidence that is left unchallenged in cross-examination. So where a party calls on a witness, they're entitled to assume that if evidence is unchallenged, it is accepted as correct, right? So in this case, the court held that the company wasn't obliged to call further witnesses. They had no reason to do so. Their witnesses' evidence was not challenged. The commissioner therefore committed an error of law and a gross irregularity by saying, well, the company's version was merely a perception. He prefers the version of the employee without assessing the credibility of the 2 witnesses, without assessing the reliability of the 2 witnesses, and also the probabilities against one another. So on this basis, the court did find that the commissioner, came to an unreasonable decision. Yes, she was charged with intimidation and violence, and the commissioner saying that blowing a whistle and, dancing doesn't amount to intimidation or violence. But the court said this took place within the workplace. It took place in the workplace where other employees were working, and the evidence that employees stopped working or hid behind machines was not disputed. And on that basis, the commissioner came to an unreasonable decision, and accordingly, the review was upheld and was actually sent back to the bargaining council for a hearing afresh.
Thanks, Nadine, for that. There was a question here, and that is, what happens if your employees don't engage in picketing at your premises, but they go and they engage in unlawful picketing at somebody else's premises? They join a picket line and engage in some sort of misconduct on the other employer's picketing line. Do you think you could discipline them? I was thinking, well, the only thing you could possibly do is if they brought your name into disrepute by doing so, would be my thought. But then that employer would need to associate that employee with the employer for you to be brought into disrepute. But I think that that's probably the answer to the question, unless you disagree. You're both nodding. Right.
No,
let's move on to the next, the important discrimination and automatically unfair dismissal cases. Talita, who is our discrimination expert, is going to deal with all 3 cases, and I'm going to let you run with all 3, team.
Thanks, Graham. Yeah, the first one is Kakana versus Railway Safety Regulator. And this is a Labour Court decision. It is a claim for an automatically unfair dismissal because Mr. Kakana said he was a whistleblower. He made a protected disclosure, and that is why he was dismissed. And that reason is a prohibited reason, and therefore his dismissal was automatically unfair. Now, Mr. Kakana was employed at the Railway Safety Regulator, and the purpose of this regulator is to oversee safety of railway transport in South Africa. He was employed in the position of executive manager, the occurrence investigations, and his job was to ensure that any incidents regarding accidents are investigated so that similar occurrences can be prevented in the future. So he went on leave in December 2017, and while he was on leave on the 4th of January 2018, there was an accident just outside of Kroonstad. he cut short his leave in order to deal with this matter, and he dispatched 2 investigators to deal with this issue. They didn't arrive at the scene timeously, according to the CEO, Mrs. Gare, and on the 5th of January, she is Mrs. Gare, who is the head, the acting chief executive. She then used a deviation procedure in order to appoint independent investigators to investigate this accident. She didn't discuss this with Mr. Kekana at all before she did this. And he was quite taken aback by the fact that there were now these 2 independent people who were investigating this accident. One of the persons who was also involved was Mr. Herman Brouwer, an executive in Mrs. Gare's office. So on the 10th of January, Mr. Kekana phoned the chief financial officer of the regulator and said that this is not appropriate. It's actually a breach of the PFMA, and it results in wasteful expenditure because the regulator pays employees to be investigators and to go to these accidents. And now these independent people were paid at a higher cost and sent to investigate this, this accident. Nothing happened, but on the 28th of February, he then made another disclosure, and that was in writing. So he wrote to the chairperson of the safety committee of the board, but he also wrote to Mrs. Gare about it. And then the matter was eventually in March escalated to the board. On the 22nd of March, we got a notice of suspension by Mrs. Gare. And she said that he is, there are concerns that he has misconducted himself because of his negligence and tardy response to that accident and the substandard reports that were delivered after that accident. So he was suspended, and a disciplinary inquiry took place in May, 2 months later. Mr. Kekana was ill and he couldn't attend the hearing, and the hearing proceeded in his absence, and a verdict of guilty was then issued. So Mr. Kekana thought this is very unfair, so he appealed, and that was only in September 2018. But be that as it may, he appealed. The appeal chairperson, an independent attorney, then held that actually he has, a reasonable explanation of what has happened here, and he recommended that a hearing de novo needed to take place. That hearing de novo didn't take place. Instead, on the 12th of February, which is now a year and a month later after the incident, Mrs. Gare then accepted the findings of the initial disciplinary inquiry. She said, "I have formed the view that your submissions to the appeal chairperson couldn't lead a reasonable trier of fact to arrive at a conclusion different to that of the chairperson of the first hearing, and therefore you are hereby dismissed." When he was then dismissed, he was required to return all the railway regulators' property in his possession. but a laptop that he was issued with couldn't be returned because it had been stolen. And the regulator then, with the final payment, deducted the amount of 7,000 Rand on the basis that it is a policy. If something is stolen, that amount needs to be paid to the regulator, and therefore they deducted that amount. So Mr. Kakana was aggrieved with this turn of events, and he instituted an automatically unfair dismissal claim, and also a claim on the basis that there was a breach of Section 34 of the BCEA, because this deduction, he said, was made unlawfully and in breach of the BCEA. The court first dealt with the issue of the 7,000 Rand and the laptop, and it held that that is governed by the standard procedures in the regulator. There is a policy that says that this is what will happen in the event that property is lost, and then we will seek to recover that amount from the employee. But the court said that was not compliance with the requirements of Section 34. Section 34 requires there to be an agreement in writing in terms of which a debt is specified in order to allow this deduction. This was not the case here, and therefore the regulator had to pay back the 7,000 Rand. On the issue of the automatically unfair dismissal, the court said, let's see. The regulator is saying he misconducted himself and there was a gross dereliction of duty in relation to the way in which he dealt with that incident. But was that the genuine reason for the dismissal? Or was the reason for the dismissal actually that he had made the disclosure about the wasteful expenditure by Mrs. Hare? And the court said a number of factors showed that the disclosure was actually the reason. He wasn't charged in January, immediately after the incident, with the shoddy work that was done or the gross dereliction of duty or anything like that. It was only after he had escalated the matter to the board that he was actually charged with these alleged instances of misconduct. When he presented his appeal, the appeal chairperson said, hold a fresh hearing. That she didn't do. She waited 6 months and then accepted the outcome of the initial hearing. That was clearly just in her own interests, because this matter was now before the board. She said, yeah, but I have been under such pressure from the president to ensure that these train accidents are investigated. I need to take strong action when these things are not done correct. But, she didn't really deal with the allegations regarding applying for the deviation and sending these external investigators. She actually just tried to get Kakana to now stop this issue. And that is, the court said, why he was actually dismissed. It wasn't because of the misconduct. And therefore, the court held that, yes, it was a protected disclosure, and yes, that was the reason for his dismissal, and he was accordingly reinstated with to the date of his dismissal in February 2019. The next case is the case of Cape Peninsula University of Technology versus Mrs. Octavia Nkabela. And this is an appeal by the Labour Appeal Court. It's a judgment by Judge Davies. And in this case, Mrs. Nkabela argued that she was automatically unfairly dismissed because she was harassed on the basis of her political opinion or belief. Now, what gave rise to this case was that it was in the midst of the Fees Must Fall campaign, and there was strife on the campus, and Mrs. Nkabela was the acting HR head at the time. There was a meeting at what they say the Sanlam Center, and they had discussed then the University of Technology's response to all of these violent protests. And one of the suggestions was to have very seriously armed security people together with dogs. And this brought back awful memories for Ms. Nkabela, and she said to the Professor Fourie, who was the one that was now in charge of getting all the security done, how is it possible in 2016 that we are resorting to these kinds of security measures involving dogs, for example? You know, it makes me think of 1976. And he took offense and he said, but honestly, you know, you don't know the seriousness of this situation. And he walked towards her with his fingers pointed at her, and she had to put her head back so that he didn't hit her on the head with his finger. And that she regarded as harassment. So the second issue was the whole issue regarding insourcing. And the Vice Chancellor had said that the insourcing was going to happen at the cost of the contract. And she said that that didn't make sense because the employees who are permanent employees of the university are entitled to benefits and the outsourced employees are not. And if they are going to come back simply on their contract amount, it is not going to be enough and there are going to be issues. And how is the university going to pay for all of these benefits? And there was conflict in relation to that whole strategy. So she laid a grievance. That grievance wasn't promptly dealt with, but about 6 months after that first incident, the chairperson of the council wrote to her and said, we have decided to deal with your complaint on a very high level. The chairperson of the council is going to deal with it, and we will take steps in order to do that. That was in June 2017. Nothing much happened, and on the 31st of October, she resigned with immediate effect. And then she instituted this claim in the Labour Court. Judge Davies said the statement of case was really very flimsily drafted, and it wasn't exactly sure what she was complaining about. She said it was a constructive dismissal that was automatically unfair. But, you know, the essence of the matter was she had alleged that she was harassed, that it was because of her political opinion, and therefore that that her harassment was automatically unfair. In the Labour Court, Judge Radke said, yes, she was harassed. She was harassed by this Mr. Fourie, or Professor Fourie, and she was also harassed subsequently in the insourcing protests by the students. And this was based on an arbitrary ground because of her view that the university was not acting in line with the policy that it had set for itself. that the judge in the Labour Court said was an arbitrary ground within the meaning of Section 6(1) of the Employment Equity Act, because it affected her human dignity in a comparably serious way, as would differentiation on a listed ground. Judge Davies in the LAC said that was not pleaded. She didn't allege differentiation or discrimination or harassment on an arbitrary ground. There was no basis for the court to venture into that area at all. What the Labour Court had to do was to determine whether she was harassed and whether that was because of the grounds that she had alleged she was harassed on. Then, interestingly, the court talked a bit about what is belief and political opinion. And that is quite relevant also now when we are talking about vaccines, because one has the right to object to having the vaccine based on a religious belief or, well, religion, belief, or opinion. The first interesting point that Judge Davies makes is that belief goes further than just religion. It's not just belief in a higher power that is protected by that right. It says the combination of these rights, which are conscience, religion, belief, and opinion, in this section in the Constitution, which is section 15, appears to signify the protection of the right to hold the religious belief together with the right to entertain agnostic or atheist views and other beliefs. The fact that the right extends beyond religion indicates that the scope of the protection extends beyond protecting the right to believe in a supreme being. And then it stops there. It doesn't go further. And that is really our conundrum at the moment in relation to belief. Then the court goes on to talk about political opinion. It says, political opinion cannot be extended to apply to any and every opinion in any matter whatsoever. Its scope must be read within the context of conscience and belief, which appears in the same section. So, rather, this term refers to a broad category of attitudes that a person might hold on matters of concern to her concerning the state, government, or society. And then it says the scope of this right would be that the opinion the person holds concerns a matter of public concern. It is expressed in a way that makes it hard to prove whether it is false or true, so whether it is factual or not, and it cannot be reasonably interpreted to be a factual statement about someone or something. So the court said this harassment that Ms. Mkabela suffered at the hands of Mr. Fourie that day might have been aggressive behavior, but the court didn't interrogate whether this was because of a political opinion within the scope that it said here. And because the court had not grappled with that question at all, that case was then dismissed and the appeal was then upheld. So the court held that the application had to be dismissed with costs and replaced that for the judgment of the the Labour Court. Very interesting. So
One just quick question.
There was no evidence that the harassment was based on religion, belief, or opinion, and that is why the case was dismissed. Her case was dismissed.
Just one quick question, and I know we've got a time constraint, so we're going to push on quite fast, but there's a question as to if an employee acknowledges in a disciplinary inquiry that they've caused damage and loss to an employer, whether that's sufficient to do a deduction or whether you actually need a written acknowledgement. I know you know the BC well.
Yeah, I think that written agreement is important. Get them to sign on the dotted line. Yeah, and the reason for that provision in the BCEA is that it mustn't be easier to claim loss or damage from your employees than from any other third party. So if any other third party causes you loss, you would institute a claim for damages in the normal course. It cannot be that you just take money from an employee's salary to achieve that. All right, I see there is a question regarding sexual harassment and how quickly those claims need to be investigated. There isn't a prescribed time period, Samantha, but the rule is that you need to do that as soon as reasonably possible after becoming aware of the act of misconduct. And yeah, it's sometimes these matters are very complex and the investigation itself takes time. So it is important not to waste unnecessary time. I think it is also important that employees who suffer harassment in the workplace come forward as soon as reasonably possible, so that they do not sit on these allegations, which may then make it difficult for the employer to investigate them. Then the last matter is a gender pay discrimination case. It is again a judgment by Judge Davies in the Labour Appeal Court concerning the claim by, Dr. Mngachi. I need Sibu to help me. Mndunjeli Nkula, I think is the correct pronunciation. She was, well, she is a lawyer, and she applied for a job at the Department of Health in the Eastern Cape in their legal department. So she applied for a position of senior legal administrative office, and the range for the salary in this role was 317,000 to 700,000. So clearly there is a range, and it is quite a broad range. So she was offered and appointed at the role at the salary of 360,000, and she was then aggrieved by the salary, and she did some digging, and she then got 3 comparators. The one was Mr. Ganyasa, the other Mr. Mantliwa, and Mr. Ngozi. Mr. Ganyasa, she said, was offered this role because he was also one of the applicants for this role. He was offered the role at 532,000, but he then declined it. So he never took the role, and she was then offered the role at 360. Then Mr. Mantliwa, he was also made an offer, which he didn't accept. And Mr. Ngozi, he was actually a person that was at a level lower than she, but because of his long years of experience through length of service, he was paid a bit more than her, but they don't tell me the amount. So she was saying all of this shows gender discrimination. And Davies then looked at section 6.4, and he says it is very important that we comply with what is in section 6.4 when we consider these things. Firstly, there needs to be employees of the same employer performing work that's the same or similar or of equal value, and that they are treated differently because of one of the protected grounds. Now, Mr. Kanyaza couldn't be a proper comparator because he was never an employee. So, end of that inquiry. Mr. Mankiwa was actually given the same offer as she, so there wasn't unfair discrimination in respect of him. And in relation to Mr. Ngozi, he was paid more because he had had all this years of service, and we've seen that the range of payment is actually quite wide, so it was quite possible so that someone who were at a lower level could actually earn more. But the reason wasn't gender, the reason was the years of service. And therefore, the case was dismissed.
Thanks very much, T. We're going to move straight on because we're constrained for some time. We've got this very important constitutional court case that Lusanda is going to deal with of Boy, where we deal with the issues of reinstatement, back pay, and stuff like that. Lou, over to you. Thanks.
So, Mr. Boy was employed by the Amatole District Municipality, and he was employed as the Senior Manager for Municipal Health Services. He was dismissed amidst various allegations of misconduct, including insubordination, conducting himself in a provocative manner, in a willful manner in relation to poor performance findings that had been made against him, gross dishonesty and misrepresentation in relation to what he put in the poor performance documentation. And Mr. Boyd disputed his dismissal, and he took the matter to the local government bargaining council. The arbitrator, after hearing the matter, found that Mr. Boyd's dismissal was substantively unfair, but on procedure found that it had been procedurally fair. The municipality ordered that Mr. Boyd be reinstated. The arbitrator ordered that Mr. Boyd be reinstated. The municipality took the matter on review to the Labour Court and said that the commissioner had committed a reviewable irregularity by ordering reinstatement of Mr. Boyd, despite the fact that evidence had been laid in the arbitration proceedings that made it clear that the employment relationship between Mr. Boyd and the municipality had irretrievably broken down. Mr. Boyd disputed that the employment relationship had irretrievably broken down. He did admit that he had a difficult relationship with his manager, but he said he was willing to continue to work with her and that the relationship hadn't irretrievably broken down. The Labour Court held that Section 193.2 of the Labour Relations Act says that the primary remedy is reinstatement unless there are circumstances surrounding the dismissal that show that it would render the continued employment relationship intolerable. The Labour Court held that although the charges could not be proven to show that there was misconduct, it was shown that the relationship between Mr. Boyd and the municipality had broken down. It therefore held that reinstatement wouldn't be appropriate, and it substituted the reinstatement order with an order for the payment of 8 months compensation. Mr. Boyd demanded and was paid that compensation, but then he took the matter on appeal and said that it was inappropriate for the Labour Court to have read in and said that reinstatement would not be appropriate. he said that by virtue of the fact that he had been exonerated of the charges against him, he should have been reinstated. He said that the crux of the matter was that the municipality said that these were the allegations against him, and based on those allegations, the continued employment relationship was rendered intolerable. And therefore, he alleged, by virtue of the fact that the allegations were now proven to be untrue, and the dismissal was found to have been substantively unfair, it followed that he should have been reinstated because the allegations about the breakdown of the employment relationship and it being intolerable and not able to continue was linked to those charges. And so as soon as he was found not guilty of those charges, it should be that he should have been given the primary remedy of reinstatement. The Constitutional Court looked at this issue. One of the things the Constitutional Court looked at was whether the Labour Court should have interfered with the arbitrator's findings. It looked at the finding in Dumo, and that in order to interfere, the Labour Court should have found that this was an outcome by the arbitrator that a reasonable decision maker couldn't have arrived at. It found that this was not true because the arbitrator had actually grappled with this issue and found that despite the fact that there was a difficult relationship, he couldn't be convinced that reinstatement was not appropriate. So the court said that the Labour Court went too far, and that based on the Sidumo judgment, the Labour Court should have looked at whether or not it was a decision that a reasonable decision maker couldn't have reached, and that its inquiry had gone further than that and was therefore inappropriate. The court also looked at the remedy for reinstatement and looked at the test for whether or not the employment relationship had become intolerable. It said that this was a high standard. It was a deliberate high standard because the point of it was for that employees who had been unfairly dismissed should be put in the position that they would have been in but for the unfair dismissal. It said that it was a high standard and higher than a difficult relationship between two people and higher than even an incompatible relationship between two people. And that if the issue was one of incompatibility, that should be dealt with appropriately as an incompatibility issue. It held, therefore, that it wasn't enough that the municipality felt that the relationship was difficult. The fact that Mr. Boy had been exonerated of the charges and it was found that it was substantively unfair did mean that he should have been given the primary remedy of reinstatement. The court said that he should be reinstated retrospectively. It did, of course, take into account the fact that he had been paid the 8 months compensation and said that those amounts that had already been paid to him should be factored in and set off in relation to the retrospective compensation. Thanks, Graham.
Thanks, Lou. So a very important case on if you don't want reinstatement in the event of a substantive unfairness, to be able to establish the complete breakdown in relationship, and it'll have to go much further than simply saying it's a difficult relationship. You need quite a lot more evidence, and so you need to be prepared basically for a finding of substantive unfairness and to be able to argue and lead evidence as to why reinstatement is not appropriate. Otherwise, you're going to be stuck with the reinstatement order effectively, as I understand it. Thanks. Okay, Melissa, over to you on the next matter, which is Kajana versus Brown, which I think has got some interesting facts. If you can just take us through Kajana, thank you.
Thanks, Graham. So this is a recent judgment that was handed down earlier this month, and it was a condemnation application in a review of an arbitration award in the Labour Court. And the facts that related to this case was that an employee was dismissed for allegedly assaulting his superior in a heated argument in his office, whereby the altercation led to his superior's spectacles being knocked off of his face. It wasn't in dispute that there was some form of physical altercation between the two employees, but the employee had claimed that he had simply pushed his superior to get him out of the office. There was evidence led in the arbitration that there was a strained relationship between the two employees, and there were issues of insubordination and insolence and disrespect by that employee towards his superior. But ultimately, his dismissal was as a result of the assault that took place. Now, as you know, in a review application, the matter must be taken on review within 6 weeks of an arbitration award. So in the arbitration, the commissioner found that the employee was fairly dismissed, and the employee then referred a dispute to the Labour Court, but was 5 months late in referring the dispute. And as you know, in a condemnation application, there are a number of factors that the Labour Court has to take into account. It has to take into account the degree of lateness, the reasons for lateness, and the prospects of success. And when considering prospects of success in a review, it also would need to consider whether that employee would be successful in a review application. And taking into account the reasons for lateness, the employee did have some explanation for why he was late in referring the dispute. It related to his union's delays in considering the matter, but the Labour Court found that he didn't explain each and every period of the delay, and the delays on the part of his union only could account for about 3 months of the delay. And the court found that when there's no reasonable explanation for a delay, prospects of success are immaterial, but the court did turn to consider the prospects of success in any event. And the court found there that the arbitrator had considered evidence that was not actually led in the arbitration proceedings, and the arbitrator also relied on hearsay evidence. So the arbitrator had relied on hearsay evidence of the superior's doctor, who allegedly claimed that the superior had suffered a head trauma as a result of the assaults. And he also took into account evidence that the glasses were found some distance away from the superior, that employees had to search for the glasses. So he took into account evidence that wasn't actually led at the arbitration proceedings. And the court had to consider whether the arbitrator would have still come to the same conclusion, even if he hadn't taken into account that evidence that was not led. And the court found that it's likely that the arbitrator would have still come to the same conclusion. There was evidence that the employee had struck his superior forcefully enough for his glasses to fall off of his face. There was a strained relationship between the two, and the employee had admitted that he had pushed his superior in order to make him leave his office. So the result of the dismissal was as a result of his own conduct, in that he had pushed his superior, and he didn't have to push his superior to get him to leave his office. He could have asked another person or lodged a complaint or a grievance against his superior, and did not have to take matters into his own hand by assaulting his superior. So the court found that there were no prospects of success in the review application, and in any event, he didn't have a reasonable explanation for the delay. Thanks, Graham.
Thanks, Melissa. And last up is Nikita Reddy from our, again, virtual Cape Town office. She's a senior associate, been practicing with us for some time. Nikita, you've got 20 minutes, so you can decide how you want to tackle the last 3 cases and whether you want to tackle all 3 or some of them. I'll leave it to you.
Thanks very much, Graham, and good morning to everyone, and thanks for sticking with us this morning. I think what I'm going to do is discuss 2 of the 3 cases, as 2 of them were actually a duplication of the same legal principles. So the first case that I'm going to be discussing today is a Labour Court judgment. It's McCloy versus Council for Scientific Research and Industrial Research. And this is a Labour Court judgment by SAS AJ, our very own Mendel SAS. And this case involves the alleged automatically unfair dismissal of the applicant as a result of her age, and whether the employer unfairly discriminated against her based on her age. Now, there are some technical legal aspects of this case that we'll not be dealing with today, but just for context, the employer raised 2 special pleas in the Labour Court, as well as some other preliminary matters. The special plea that the court proceeded to deal with is the allegation that no automatically unfair dismissal dispute had actually been conciliated between the parties by the CCMA prior to the dispute being referred to the Labour Court. So just in terms of the key facts, that you understand the principles in this judgment, the applicant initially referred an unfair labour practice dispute to the CCMA on 3 December 2019. And it's important to note that no other dispute had been referred to the CCMA at any time. Her employment subsequently terminated on the 31st of December 2019, and conciliation proceedings then took place in January, and the CCMA issued a certificate of outcome indicating that an unfair discrimination dispute between the parties remained unresolved, and that the dispute could be referred to the Labour Court for adjudication. So it's just important to note that the applicant actually referred an unfair labour practice dispute to the CCMA, but the certificate of outcome reflected that an unfair discrimination dispute remained unresolved. The focus of today's discussion then is on one of the special pleas raised and on the issue of whether the Labour Court actually lacked the necessary jurisdiction to adjudicate the automatically unfair dismissal dispute, seeing that the applicant had only referred an unfair labour practice dispute to the CCMA. So the applicants in the Labour Court contended that the automatically unfair dismissal dispute had also been conciliated during the conciliation proceedings, but the employer, of course, denied this. And the court found that in order to determine whether it did actually have jurisdiction, it would need to consider what was said during conciliation proceedings to establish whether the dismissal dispute was in fact conciliated. Now, that might sound strange to some of you because ordinarily we know conciliation proceedings are off the record and you're not ordinarily entitled to introduce evidence about what was discussed in the CCMA. And the court went on to consider the CCMA rules, which provide that conciliation proceedings are private and confidential and are conducted on a without prejudice basis. But the court also then referred to the Constitutional Court's judgment in September and others versus CMI Business Enterprise, where the Concord had to determine whether courts are in fact allowed to have regard to evidence resulting from conciliation proceedings. And this judgment might be familiar to some of you, but the Labour Court referred to September and held that the general rule is that the referral form and the certificate of outcome are prima facie evidence of the nature of the dispute which was conciliated. However, a party alleging that the nature of the dispute differs from what was actually said could adduce evidence to such effect. Furthermore, the Concord held that the ultimate question which needs to be asked is whether during conciliation, the substance of the dispute became apparent. And in order to adduce evidence to this effect, one would be able to rely on the record of the conciliation process. So on that basis, in the September case, the Constitutional Court held that evidence as to the nature of the dispute dealt with during conciliation may actually be led, and that is not privileged. So relying on September, the Labour Court in this instance directed the parties to file supplementary heads of argument addressing the September matter. And the court considered these submissions and ultimately held that there was no evidence before it as to what transpired during conciliation. And it was accordingly unable to determine whether the Labour Court had jurisdiction to determine the dispute. And that question could then be resolved at the commencement of the trial through the presenting of evidence by the parties. So the key takeaway from this judgment is that not everything said during conciliation proceedings are without prejudice. So it's something to be aware of when you're dealing with conciliations. Whilst the actual settlement negotiations are without prejudice, that is whatever offers you might want to put on the table and discuss, what is said about the type or nature of the dispute is not privileged. And this means that what was said during conciliation proceedings about the true nature of the dispute may be referred to and relied upon in subsequent proceedings to determine the actual dispute. So that's a practical takeaway, particularly for employees to bear in mind that when you go to the CCMA to conciliation proceedings, not everything that you say in those proceedings are going to be without prejudice and completely off the record.
So the question, sorry, just Nikita is being asked as to what does it mean? Should we then keep notes at conciliation, or will it turn on the oral evidence as to the nature of the dispute? But essentially, I think you're going to have to keep it. They're not recorded, as far as I know. A conciliation would not be recorded. So you would have to keep some detailed notes And to make them contemporaneous, probably do it immediately after the meeting has been held.
Thanks, Graham. And yes, that's right. And I think what the court is saying here is that you would then need to lead evidence. You'd have to lead a witness to actually say what actually was said at conciliation proceedings. And in this case, the lawyers were making submissions on behalf of their clients about what was said. And the court said, well, your legal submissions are not evidence. And we actually need a witness to take us through what was said. So the next case that I'd like to discuss is a Labour Appeal Court judgment of Ngadi versus Jenkin and others. And this is a LSE judgment against the judgment of the Labour Court, where the Labour Court dismissed an application to review a ruling issued by a commissioner refusing condonation for a late referral of a dispute in terms of Section 10 of the Employment Equity Act. So we're dealing here with an unfair discrimination dispute. The facts of the matter are quite straightforward. The employee had been employed as a shift leader, grade 11, since 2008. As a grade 11 employee, he did not fall within the bargaining unit and within the scope of a collective agreement, which is referred to as the house agreement. And the employee alleged that his exclusion from this house agreement amounted to discrimination because he is effectively paid less than his subordinates and does not qualify for certain benefits. He then referred a dispute in July 2016 to the CCMA in terms of Section 10 of the Employment Equity Act, alleging unfair discrimination on an arbitrary ground. Another key issue in this case is about the time period within which to refer a discrimination dispute, which in terms of the Employment Equity Act is within 6 months of the alleged act or omission. At the CCMA, the commissioner here seemed to have assumed that the referral was out of time based on the 6-month period and declined condonation, even though he was aware that the employee's position was that condonation was actually not even required because the discrimination was ongoing. And the commissioner failed to deal with that issue, but he made a ruling on the belief that the referral was out of time and because the employee had not established good prospects of success. So the employee wasn't happy with this ruling and he brought a review application in the Labour Court to set it aside. And the key issue before the Labour Court was whether condonation was in fact required. And the Labour Court ultimately held that the employee was obliged to seek condonation and dismissed the review. On appeal, the LEC held that the Labour Court and the Commissioner proceeded on the assumption that the dispute had been referred out of time and accordingly that condonation was required. However, the court held that both had failed to appreciate the employee's argument that the dispute was not out of time because the discrimination was ongoing or repetitive. And the Labour Court was quite critical of the LEC was quite critical of the Labour Court's finding that condonation was required because of the absence of detail about the discrimination. And the LSE held that the finding that the merits of the dispute are relevant to the determination of jurisdiction is mistaken. And the court said whether a claim is meritorious or whether it's good or bad in law is actually immaterial to the question of jurisdiction. And it was incorrect for the Labour Court to find that the CCMA had no jurisdiction simply because it had doubts about the merits of the dispute. So the LSE ultimately set aside the ruling and referred the matter back to the CCMA for conciliation. So there's two important points emanating from this judgment. And the first one might seem obvious, which is that the merits of the matter are not relevant to the question of jurisdiction. So it doesn't matter whether the opponent or the court thinks that the employee might have a good or bad case when determining jurisdiction, that's not relevant. And secondly, cases of alleged discrimination can be brought months, even years later, where it's alleged to be an ongoing act or omission of discrimination. So unfortunately, in this case, the court didn't get an opportunity to address the question of relief because it was in essence dealing with jurisdictional points. So it's yet to be seen what kind of relief the court will afford a claimant who is actually able to establish ongoing acts of discrimination over a prolonged period, and whether this will be limited to the 6-month period prescribed by the Employment Equity Act, or whether the ordinary principles of prescription will apply. But what is clear is that an employee who alleges ongoing discrimination is not confined to that 6-month period in the Employment Equity Act, to refer their dispute. And there was the third case that I was going to discuss, in effect, actually just confirms the LSE's approach in this matter. It's a Labour Court judgment that applies the principles in this case, where an employee had alleged that she was being subjected to unfair discrimination on an ongoing basis by her supervisor. And the court applied the same questions to find that both the CCMA and the Labour Court did have jurisdiction because the employee alleged that it was ongoing acts of discrimination.
So in essence, when you're dealing with a salary discrimination dispute, the fact that salary is paid every single month means that that discrimination occurs every single month and is an ongoing discrimination. The issue is, because of the requirement to refer within 6 months, is whether you are then limited to claiming for only the 6-month period that you don't have to apply for condonation for, and whether the previous salary payments prior to the 6 months are out, or even whether, if that's not out, whether the 3-year prescription period applies. So that's still yet to be determined. So it's quite a complex issue, but condonation is not required in an ongoing discrimination matter. And the second one you dealt with was a sexual harassment matter, where some of the sexual harassment took place way before, years before the event, but because it was repeated, a court said essentially you don't need condonation because it was repeated sexual harassment that you were complaining about effectively. Thank you very much, Nikita, and thanks for that. And that brings us to the end of our program. Thank you all for bearing with us and staying with us through the period. I wish you all well for the Christmas and New Year break, if we're going to get a break, given the new variant, but let's hope that we do. And we look forward to seeing you all in the new year. Thank you very much for your participation, and thank you, panelists. Cheers.